being an attorney is so easy that we can all do it in a day, when it took everyone here at least, well, I would say at a maximum, 7 years.
So I do find that I have jurisdiction over you. So that matter is settled. Would you like to have counsel?
Not true, so I object to that. That's not true. You never gave me how you jurisdiction.
What part's not true? Do you live in the city of Taylor?
No, I'm not going to say that it's true, as in, not in the sense that you mean it, no.
At this opening moment, the judge is trying to establish something incredibly basic: identity. In any courtroom, confirming who is present is the first procedural step before anything else can happen. But instead of giving a direct answer, the defendant introduces unnecessary complexity by avoiding a simple confirmation of his name. This may seem minor, but legally it's critical. Courts operate on clear records, and identity must be established without ambiguity. By resisting this step, the defendant immediately creates friction and signals that the hearing may not proceed smoothly. This sets the tone for what becomes a pattern of avoidance and procedural disruption.
Thomas Seeger, appearing on behalf of Mr. Hart.
I have somebody in my hearing room listed as Ryan Hart. State your name for the record, please.
My name is Ryan John Family Hart.
I don't have anyone on my docket listed as Ryan John Family of Hart. I have an individual listed as Ryan John Hart. That's either you or it's not. You get to tell me whether or not that's your name. If it's not, then I need to call a different matter and bring somebody else into my hearing room.
You're all right. I'm the representative of that entity, yes.
That's not an answer, sir. Your name is either Ryan John Hart, in which case you're invited to participate in the proceeding today as Ryan John Hart, or you're not Ryan John Hart, in which case I have no use for you to be in this hearing today. So tell me your name so that I can determine whether or not you're the proper person to be called in this case.
My name is Ryan John Hart. May I ask a question, Your Honor?
No, you may not. Mr. Hart, this is not a complicated process, and this process does not get less uncomplicated. When I call a case, I start by identifying the parties that are to the case. When I'm confident I have the correct parties to the case, I proceed then and decide how to go forward. In this case, your difficulty, and I think intentional difficulty, is affecting the ability of the court to be able to proceed and to conduct its business. That's relevant to a lot of points, but most importantly, it's relevant to a pending motion that your attorney filed, presumably on your behalf, but I sense that it's not only on your behalf, it's also on your attorney's behalf. And so we're going to take up that motion. But your difficulty in basic things like telling me whether or not you're the party to a case is thwarting the court's ability to timely get its business done. I'm turning to the motion now that's before the court today, which is the motion to have attorney withdraw and to have you represent yourself, Mr. Hart. The court does not find that motion to be well placed, and I'm not going to prevent it. And the reason is there are several steps that need to be taken in order for you to be able to assert your right to represent yourself. First and foremost, I must find that your assertion of that right is unequivocal. I don't have that. What I have is your attorney's motion, and I recall very clearly and plainly the last couple of hearings that we've had. A couple of hearings ago, I had findings that I made based upon a competency and criminal responsibility examination. You were found both competent and criminally responsible by the court after assistance from the Center for Forensic Psychiatry and after an in-depth intervention and interview by them. I made the findings, your attorney agreed with them, and the prosecutor agreed. I have not once heard you make any type of unequivocal request at all. What I instead heard when I consider whether or not there's an unequivocal request for you to represent yourself is your attorney explained to me, I think this was 2 or 3 hearings ago now, that he was somewhat conflicted. And these are not his exact words, but this is what I recall from it. He was somewhat conflicted. You had wanted him to file various different motions, which the attorney did not find were supported by law. And the communication that I had in response to Mr. Seeger, again, was some version of this. I told Mr. Seeger that as the attorney, he and he alone chooses which motions are to be filed and which are supportable by fact or by existing case law or by the extension of existing case law. If he can't make those arguments that are good faith supported by law or an extension for the law, then he's not permitted to file the motions. It was at that point that Mr. Seeger then suggested that another solve for him could be that you could represent yourself. In other words, the implication that what Mr. Seeger was making is that if you were representing yourself, you would not be constrained in the way that he is. It would allow you to file whatever frivolous motions, I'm using that word, Mr. Seeger didn't, whatever frivolous motions you wanted to. And so the request to have you represent yourself as made through your attorney is not found, number one, by the court to be unequivocal in any way. Number two,
Here, the judge firmly reasserts control over the courtroom. The defendant attempts to shift the structure of the hearing by asking questions out of turn, but court proceedings follow a strict order dictated by the judge, not the defendant. This moment is important because it reinforces the authority of the court and the necessity of procedural discipline. Without that structure, hearings would quickly descend into chaos. The judge's response is not personal, it's procedural. She's ensuring that the process remains orderly and legally valid. This is a key reminder that courtroom participation comes with rules that must be followed.
go through with you and be confident that you understood the maximum penalties associated with the crimes. I have every reason to believe that you understand the maximum penalties, but I have every reason to believe that if you and I had a discussion about what those maximum penalties were, you would express confusion and you would not express a knowing, confident, and voluntary understanding of those things. And so I'm not yet even going to get to that second step. I also, of course, would have to, under People versus Anderson, the binding Michigan Supreme Court case regarding waiver of constitutional right to represent yourself, I would have to make specific other findings. And those findings specifically are that I would have to determine, after a conversation with you, that you acting as your own attorney would not disrupt or unduly convenience or burden the court in the administration of the court's business. What is plain, obvious, and unarguable in over the last 2 or 3 hearings is that if you were permitted to represent yourself, you would make the court's administration of justice difficult, you would delay matters, you would be disruptive, and your representation, therefore, of yourself would be unduly inconvenient to the court and the court's operation of its business. For that reason, even if I found that you otherwise made an unequivocal request, which you haven't, even if I found that you clearly understood and you expressed your waiver knowingly, intelligently, and voluntarily, the court would still not grant your request through your attorney to represent yourself under specific circumstances here. It's my firm finding, based upon the background that I'm aware of, that to allow you to do so would only encourage you to file what are very spurious and frivolous motions. It would waste the court's time, it would waste the prosecutor's time, and although it would waste Mr. Seeger's time to have him remain on, the court also notes that even if there is good cause for Mr. Seeger to withdraw, the Michigan rules of professional conduct allow the court to continue an attorney's appearance and order that an attorney continue on a case even when there's good cause to withdraw. And so I choose to exercise the discretion provided to me under those Michigan rules of professional conduct and the Michigan court rules and Michigan case law in denying any request to have you represent yourself. You are and will remain represented by Mr. Seeger until further order of the court. Mr. Seeger, did you need then some time to discuss the effect of that ruling with Mr. Hart before I decide how this case needs to resolve?
I do,
by way
Your
of trial.
Honor. Additionally,
Your Honor,
amended off.
Your Honor, I have something to say. May I speak?
Mr. Hart, you don't get to
Your
decide
Honor,
when things are said. That's again part of the issue.
The judge is not on the
Presenting
speaking
yourself.
in more than 3.
Mr. Hart,
Three-
this will not be an argument. This case will not proceed by me talking over you or you talking over me. Court proceedings by law and by procedure, Mr. Hart, are to be ordered. And they're to be in a specific order, and that order is dictated by the trial court judge. That's me. It's not dictated by an individual who's charged with criminal offenses, you. And so I'm going to exercise my discretion to control those proceedings. You right now, Mr. Hart, are free on bond. I don't particularly have any care as to whether or not you're free on bond or whether or not you sit next door, except to this point. For today, I'm going to expect that you disagree with my decision on your motion to have you represent yourself. I'm going to therefore excuse any further appearance of you for purposes of today's hearing and today's hearing only. I'm going to set this matter for a new hearing after I hear from your attorney and from the prosecutor. That new hearing is going to be set in person. The reason I choose in my discretion to set it in person is because if you're disruptive or unduly burdensome to the court at the next hearing in person, I'm going to view it as a violation of your bond conditions. And if I view it as a violation of your bond conditions, you're going to be subject to the contempt powers of the court, which includes me revoking your bond and you sitting next door. Because if I have your bond revoked and you're sitting next door, I'll know that Mr. Seeger can locate you and communicate with you. And if you have your bond revoked, I'll know that I'll be able to better control the situation than I can over an electronic communication like we're doing now. Because as you've demonstrated, the only way I can control the proceedings right now is to mute you so that you can't speak over me. That's not an effective way of running a courtroom, but it's the only way that I'm given your attitude, experiences, and your frustration. Mr. Seeger, did you wish to make a responsive record?
No, Your Honor, I do understand the court's ruling and I clearly will abide by it. Be that as it may, Your Honor, and I will discuss this with Mr. Hart. There was an amended offer that was extended.
Can you please speak up so that Mr. Hart can clearly?
Sure, Your Honor. There was an amended offer that was extended, which is much more favorable than the previous offer. I will discuss it with him. He can determine how he wishes to proceed.
All right. Did you want to, for purpose of the record, state that offer on the record?
Your Honor, my understanding is that he could plead to one count of attempted resisting and obstructing, which would be a misdemeanor in lieu of dismissal of the defendant charge together with the habitual offense.
What was the habitual offender notice that was charged?
It was I don't have it in front of me, Your Honor, because I just have the motion.
Your Honor, he's subject to a habitual 4. I believe it's on the information.
And I just didn't have the file in front of me, but do you disagree with that, Mr. Seeger?
No, Your Honor.
All right. So, Mr. Hart, it's very important that you not only hear the offer that's been made as an offer to an attempted resist and obstruct charge for dismissal of the existing charge as well as a habitual 4th, but it's fundamentally even more important that you talk to Mr. Seeger about that. He can give you advice. You ultimately get to decide how to proceed, and it does not matter to me how you proceed, so long as you proceed with the understanding that court procedures require structure, and that structure will be followed by you and by anyone else that's in this courtroom, or there will be alternative options considered by the court. Mr. Ziegler, anything further on any of that the people would like to offer?
No, Your Honor.
No, sir.
All right, the court will set this matter for a status conference next month. I will require that everyone in this matter be in person for the reasons I've already explained. Mr. Hart, you're free to sign off now. I expect you'll talk with your attorney and be here in person next month. You'll get a notice in the mail. Court notes we do have the Wexford County Jail as well as Lynn Goetz. I think Lynn Goetz is one of the attorneys with Ms. Savalla's office, correct? That's right. All right, the court next calls a matter of people of the state of Michigan.
State of Texas versus Courtroom Pugh. Can I have parties announced for the record for the state,
Stacey Harrington for the state.
for the defense?
Kenny Callahan for defense, not ready.
All right, and are you Mr. Pugh? Could you unmute for me, sir? It's the longest key on the keyboard. Just hold it down. Are you Courtroom Pugh?
Now we see a deeper legal issue emerge: the defendant's desire to represent himself. While individuals do have the right to self-representation, it is not automatic. Courts must ensure that such a decision is made clearly, knowingly, and without confusion. In this case, the request is coming indirectly through the attorney, which raises concerns. The judge points out that there has been no clear, unequivocal statement from the defendant himself. This matters because waiving legal counsel is a serious decision, one that can significantly impact the outcome of a case. The court is obligated to protect that right carefully.
I grant that name to court on special deposit for a future return on my interest, Your Honor.
All right, thank you very much for your announcement. That's for the record. That's Courtroom Pugh. Mr. Callahan, is that your client, Mr. Pugh?
Yes, ma'am.
All right, we're proceeding by video because of the pandemic. Any objection from the state?
No, Your Honor.
Any objection from the defense?
No, Your Honor.
It's the court's understanding that there's still an pending appeal in 2018 CR 6054. Is that correct, Mr. Callahan?
Yes, ma'am.
State, is that correct?
Yes, Your Honor.
All right. In cause number 2018 CR 6052, Mr. Pugh is scheduled for trial. Defense, you've announced not ready. Is that correct?
Yes, ma'am.
Are you requesting defense and state that the trial in cause number 2018 CR 6052 not be called or take place until the appeal is final in cause number 2018 CR 6054 state?
That is correct, Judge.
Defense?
Correct, Your Honor.
Ms. Ferguson, can I have a reset date on Mr. Pugh? Mr. Callahan, when do you think that final notice will be given?
It would be speculation. I'll say 3 weeks.
All right, Ms. Ferguson, can you reset Mr. Pugh for 45 days, please? And of course, Mr. Callahan, if that is done before then, just let the court know and we'll put him on the docket sooner than that.
Yes, ma'am.
And I'm just waiting for a check. So we're going to come back on May 23rd.
May I address the court? Will it be in person?
No, you'll appear on Zoom on that date. And then what will end up happening if nothing is able to be worked out, then we will have a jury trial the very next day.
Yes, ma'am. May I be excused?
Yes, and it appears that your client is trying to say he is incompetent by his announcement. So if you would like to have him evaluated, please do that before that date.
Yes, ma'am.
Do you need to speak with your client?
Yes, ma'am.
All right, when I send you to the breakout room, Mr. Callahan, make sure that your client comes out of the breakout room before you leave the breakout room.
Yes, ma'am.
Thank you. Thank you. So let me find you. I'm sending you to number 2.
Got it.
And Mr. Pugh, I'm sure you know how to get to breakout room number 2. All right, Ms. Harrington, if you don't have anyone else with us, you're excused.
Thank you, Judge.
All right, thank you, Mr. Callahan. You're excused. Norma 16B, Pugh can go back.
Your Honor, may I address the court?
Yes.
Mr. Pugh's not incompetent, but he wishes to represent himself. I told him that you would question him, advise him to the unadvisability of that at some point in time.
All right, thank you. Well, the way he's addressing himself to the court is improper. So it appears that he is not qualified to be an attorney for himself. I don't know why people think being an attorney is so easy that we can all do it in a day when it took everyone here at least, well, I would say at a maximum 7 years. You know, people think they can read a book and they've gone to law school. If that were the way things could be done, then everybody would do it and nobody would have wasted time obtaining law school loans.
I understand.
Yes. So, Mr. Pugh, we're going to send you back.
Well,
All right, Mr. Martin, I just want to clarify something because I am inclined to grant your motion for the appointment of counsel. But the problem is inside your motion for counsel, it also states that you are not consenting to the jurisdiction of the court. So if you're not consenting to the jurisdiction of the court, how is this court supposed to grant your motion for appointment of counsel? I already have jurisdiction over you. That's already been established clearly. So do you want counsel? Because if you do, I'm going to appoint counsel.
yeah, I still want the counsel, but like I said, without the fraudulent presumptions and all that.
This is a pivotal moment where the judge explains why allowing self-representation could be problematic. According to the record, the defendant has been pushing for motions that his attorney believes are not supported by law. Attorneys are ethically bound not to file arguments they know lack legal merit. However, a self-represented defendant isn't held to the same professional standard, which can lead to a flood of irrelevant or legally invalid filings. The judge is essentially Armenian. He ka enus Armenian, he a enus Armenian, he na enus Armenian, he ha enus ing that outcome, recognizing that it would waste court resources and delay justice. This highlights the balance courts must strike between individual rights and maintaining an efficient legal process.
But and
Sure, hang on. If you could speak up and enunciate, because I don't know if it's maybe a connection error or if I'm just having trouble hearing what you're saying. So I just want to make sure that what you're saying is clearly stated on the record, okay?
okay. Let me move my phone up away from my desk. I think that's a little bit. But yeah, still want counsel.
Okay, so you are consenting to the jurisdiction of the court, and I can grant you counsel, yes?
No, I'm not consenting to the jurisdiction of the court.
I
That's
don't
all.
know what you're saying, sir.
He said he's not consenting to the jurisdiction.
You're not consenting to the jurisdiction of the court? Well, I've already found, and first off, I find that I do have jurisdiction over you in this matter. You came to the location, like I stated before, you came into the location and availed yourself of all of the benefits and services that you can find here, emergency services, road services, etc. You actually reside in the city of Taylor, so that alone is enough to have jurisdiction over your person in this matter that occurred in the city of Taylor. So I do find that I have jurisdiction over you. So that matter is settled. Would you like to have counsel?
Not true, so I object to that. That's not true. You never gave me how you jurisdiction.
What part's not true? Do you live in the city of Taylor?
No, I'm not going to say that it's true, as in not in the sense that you mean it. No, or you're asking. It's fraudulent.
So do you astral project into the city of Taylor then, from somewhere else, or I don't understand. Living is, I don't know, breathing, live, reside, Clifford Street. You know what I'm saying?
Yeah, I mean, well,
keep stuff.
The thing is, if someone, lives in a house, it's fraudulent presumed that the corporation, the fiction they're living in, it's all legalese.
All right, so you're not a corporation. I do find that you have jurisdiction. I have jurisdiction over you. I will note your objection for the record, that claiming that that's not true. I am going to appoint House counsel to you, because you definitely need somebody who can understand and explain the law to you and be on your side with regard to the case. So I'm going to appoint House counsel again. And I'm going to put you into the breakout room, and House counsel will be in to speak with you so you can speak privately.
All right.
Breakout room 3, House counsel 3. Mr. Fanto, I'm just curious if this matter is set for trial next week. Is there any potential for resolution? If so, we can come back this afternoon with it if he needs more time to think.
Well, I'd like to have more time with Mr. Martin this afternoon.
All right, so let's. Can you tell Mr. Martin, because if you guys want to talk, it's fine.
That's fine.
I want to be able to send everybody else to lunch.
Gotcha.
All right, and then just let Mr. I'm gonna let you and Mr. Martin talk. If you guys want to put it on the record when we come back at 1 o'clock or 1:15, that's fine. Have them sign it then.
Okay, thank you. I'll have him do that.
All right, so I'm gonna move you guys to breakout or House counsel, whatever. There you go. All right.
Well, he's still in the room. I can just go back to the room.
Oh, well, yeah, either way. All right.
Okay.
And we'll see everybody else back at 1:15.
Okay, very good. As a criticism, it's just the law doesn't allow me to do certain things. And Mr. Martin disagrees with the law, and that's his right. But Mr. Martin's come to the conclusion that he doesn't believe that I can effectively represent him. And after, like I say, over 2 hours of discussions with Mr. Martin, I believe I'd have to agree with him.
You are agreeing that the two of you disagree, or that you just can't represent? Because I do. No, I guess I would have to disagree with your own statement, because I think you're very confident in every case I've seen.
No, I appreciate that, Judge. Yeah. Based on our internal disagreements in terms of how the case should proceed, what the law is, strategy, how to apply the law, I just cannot, in his mind, effectively represent him, and I can't represent him the way he wants me to.
So you believe that he believes that you?
I do, yes.
Not that you actually wouldn't be.
No, I'm in terms of this case, I'm more than able to go forward with it, but under the circumstances, after, again, this is based on long conversations with Mr. Martin, just don't think that he's comfortable with me proceeding.
Mr. Martin, is that correct?
What's correct is, yes, we certainly don't agree. We did talk for a long time, and it's not simply just a disagreement. I don't think he's violating my right to effective counsel based on one. He wouldn't even do the basic photocopies.
Here, the defendant challenges the court's jurisdiction, a common argument in cases like this. However, the judge clearly explains why jurisdiction applies. The defendant resides in the city and the alleged incident occurred there. Jurisdiction is not optional, it's determined by law, not personal agreement. Even if a defendant refuses to consent, the court can still exercise authority if legal criteria are met. This moment underscores a key legal principle. Participation in society, such as living in a city, comes with obligations under its laws. Rejecting that framework does not remove one from its reach.
Paperwork, I told him I wanted to get photocopied, for the court and jury, such as, laws. Used for my defenses, relevant for my defenses.
Sure, but you do understand that any instruction on the law to the jury is done by the judge. You understand that?
I don't understand. I don't agree with that, or
no, sir. I literally am charged with instructing the jurors on what the law is and what the elements of the case are.
Yeah, I mean, that's fine.
I'm going to instruct the jurors that any instruction that they hear from the attorneys to disregard, and you're only going to take instruction about the law and what the law is from me, because there's literally criminal jury instructions that are put out by the Michigan Supreme Court that are used in trials, and they've been vetted over the course of hundreds of years of tweaking and Supreme Court challenges and you name it and everything else. So that's literally what the jury is getting told, is they're going to get told what the law is, and that's going to be told to them by me. Do you understand that, right?
But but I don't agree to that degree, but to that degree. But as long as you don't knock out my right, I also have the right to present jury instructions on the law of the matter. So, so long as
you have the right to present proposed jury instructions, yes, and I'll make the determination of what the instructions will be to the jury. So, but first, let's deal with this matter here. You're saying that you no longer you wish to have the court-appointed attorney, and now you do not wish to have this court-appointed attorney. Is that correct?
But only in the sense of I moved to have another one appointed in his place, since he's being ineffective based on he won't even photocopy. Not just a mere disagreement, but it's the fact that he won't even photocopy. I asked him to, let me go there first, office, photocopy, so I have enough copies to do, because I don't have a job now. So I can't.
Well, photocopy what, sir? You want him to photocopy what?
I have just several things written down in the law and things that need to be copied out of the Constitution. Just several legal, legal areas to be copied out of the law, and just stuff that's relevant to my defense. So he should have given me no problem with photocopying. That problem. So that's really showing his ineffective, violating my right of. So
yeah, but listen, that's not photocopying is not an attorney's job. If you want something photocopied, go to the library and photocopy it yourself. The attorney's job is to talk and understand and be able to give advice about the law. He already knows the law. He doesn't need a photocopy in front of him. He already knows what the law is.
But as I just said, based on I do not have a job now to pay for the copies.
So you want him to pay for? So that's the Rob. You want him to pay for photocopies that you want to make,
right?
Well, you're more than welcome to just have the. Listen, your attorney doesn't need the law in front of him. He already knows what the law is. So if you want a copy of what the law is, you're more than welcome to go to the library and check out a book that has the law in it. You can just bring the book with you. And take the book back to the library afterwards, free of charge.
Again, I need paperwork photocopy that's relevant for my defense to present it to you and the jury. I have that right.
First off, listen, you're not presenting any paperwork to the jury if it's about laws. If you're going to try to place things into evidence, you can lay a foundation and you can put in proposed exhibits for evidence, and then I'll make my rulings based on the rules of evidence, whether or not those are supposed to come in and should come in, and whether they've had proper foundations laid, whether they are both reliable and accurate. That's the two things that we're really looking for. So, and if they comport with the rules of evidence, then I'll admit them as your defendant's exhibit, whatever, 1, 2, 3, or 4, whatever the exhibits that you have are. So, this is a situation of driving on a license that's been revoked or restricted. So, what evidence is it that what proposed evidence do you have that you would need? Because we'll make copies here of that evidence as it gets admitted. Because I'll put a true copy in the court file. I can give a copy to the witness so they can see, so that kind of thing. But so as far as the motion to remove Mr. Fanto and the House Counsel crew that I have here, which includes Mr. Kasicki and Mr. Coots, I'll once again grant that motion. I'm not gonna request any fees or anything or costs from you, because I did appoint them. Then you said you didn't want them. Then you asked for them. Then I gave them to you, and then you went back and said you don't want them now. So, with regard to a different attorney, do you have another attorney that you wanted to hire? Is that what you wanted to do, or you want me to appoint one to you?
I don't have money to hire an attorney.
Sure. So I'm going to go ahead and appoint one to you. Let's see. I can pretty much let me just take a look here. The possibility. All right. So I'm going to refer this to Miss Patton from the MIDC, and I will have an attorney here for you Tuesday for that jury trial. I'll be ready to go.
Well, that's what I wanted. Now the attorney being appointed.
We'll see you on Tuesday, sir. I'll have a court-appointed attorney here for you.
Okay, but...
All right, see you Tuesday.
Thank you.
Motion granted. All right.
In the end, this case highlights the critical importance of courtroom procedure, legal representation, and adherence to established law. The judge consistently focused on maintaining order, ensuring clarity, and applying legal standards, whether addressing identity, jurisdiction, or the right to counsel. The defendant's repeated attempts to challenge those fundamentals ultimately limited his ability to effectively participate in his own defense. The court's rulings were not based on opinion, but on structured legal principles designed to keep proceedings fair and efficient. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.